folks. This is Right Talk, production of Tilting a Windmill. And today we have a special guest with us, John Bosta. And John, why don't you go ahead and introduce yourself a little bit.
My name is John Bosta, and I live in Amargosa Valley, Nevada, and I own property in the Pahrump Valley. I was born in Nevada, educated in Nevada. In 1962, I moved to Susanville, California, and taught school there for 32 years, and then I returned to Nevada. I started teaching school in Tonopah in 2000, and in 2002 I was transferred to Amargosa Valley, and I've lived in Amargosa Valley since. I own property in Amargosa Valley, and I'm on a well, and I'm concerned about the water in the Amargosa Valley. I took up a grievance against the dairy because of their pumping the groundwater and the Kona depression because they're pumping over 1 million gallons of water a day. So it's affecting the wells of everyone within a 3-mile radius of the dairy. I've done a lot of research, and I think the point is that the research shows documentation that is not being followed by the local governments, the Water District Board, Nye County, State Engineer's Office, even the Nevada State Legislature. And they're just, in my opinion, violating the law.
Well, I have to agree with you, John. And when you mentioned the coning at the dairy, maybe you can explain to the viewers here what coning is, because it's maybe a term that they're not familiar with.
A Kona depression is that when you have a deep well and you pump the water, what it does to the water table is it makes an inverted bowl. And so basically what happens is that as the aquifers draw down, if you have a well at 140 feet, basically the Kona depression can take all of the water away from your well. And so basically your well is high and dry.
Okay, so in other words, by the dairy out there pumping 1 million gallons a day of water, which, folks, that's a lot of water when you think about it. You being nearby there, that just literally it sucks so much water that the aquifer can't even fill back up again from any refill. It's just down.
Well, that's exactly what's happened to the groundwater here in Pahrump, and basically the water table has been overpumped, and areas in Pahrump the land is subsiding just like it did in Las Vegas, Nevada. And so the problem is that if you take a look at reports that you have back in 1970, is just what's amazing is that you had 45,600 acre-feet of certified water rights, and you had 45,416 acre-feet of water rights for a total demand of 91,023 acre-feet of water, and that was pumped for years. And the water table in areas of Pahrump was reduced as much as 60 and 80 feet.
Yes, I could add something to that, John. And let me clarify something for the audience here too. When we're talking about an acre-foot of water, we're talking, again, I think I've explained that to you before in other videos, but I'll go ahead and bring it up again here, because I know this is some new material for a lot of you watching this. An acre-feet of water is, if you take a surface area of 1 acre and then you fill it up with 1 foot deep of water, then that's 1 acre-foot of water. And let me explain what I found out this week since I last talked to you folks about this. My wife and I tracked down the well driller for our well here, and we got a hold of what's called a well log. And a well log is something that the well driller produces when he comes out and drills a well. It tells all about what material he drilled through at each depth, what he came up with, and how deep the well was. And there's a mark on there where it says how far down he drilled until he first hit water. Well, in our property, I know when we had the static level tested recently, our water is at 83.5 feet. In other words, from the top of our well down, you have to go 83.5 feet before you hit water. In the well log, we were at 45 feet. So my property, where I've set here in Pahrump, the water level has in a sense dropped 40 feet. And the well was drilled in 1991. So 1991 is about 24 years ago. And so in 24 years, I've lost 40 feet of depth. And so if you just have to take the number of 40 feet and divide it by the years, you can see that each year I'm losing approximately 1.5 feet of water level, water depth at my property. And so it's not hard to extrapolate from that in just a matter of a few years, I'm going to have to drill the water well deeper. I'm going to have to pay a well driller to come out and drill it deeper because I'm going to be out of water, just like John was saying, where the coning effect has sucked it down out in Amargosa Valley. Well, here in Pahrump, I mean, we're being sucked down, and so in the news, they've been mentioning that wells have been dropping as much as 2 feet. Well, mine's dropped 1.5 feet. And so I'm not real happy about that because it's going to be an expensive ordeal to have the well drilling company come out here. And so what you folks can do, if you know the driller of your well, if you know who did it, you can contact them and they can provide you with the information on your well. And so then you can have a static test done. And Greg, what's Greg's last name?
Greg Dan.
Yeah, excuse me, I'm sorry, my brain went frank there. Greg Dan, who did my water static test, he's doing it for free, and you'll just be a matter of getting in line because I know he's trying to map the whole area, see where we're at water-wise by going around and doing static tests on wells. And then you could use the same formula I did, how much your water well is dropping, and then how deep it is, and just go from there. This shows you what the state of your water well is. I'm going to stop there.
Well, let me give you an example. My well was drilled in 1996, and the static water level was at 90 feet.
Okay.
Greg came out and did a static water level, and my well now is at 123 feet, and my well was drilled to a depth of 140 feet. So I have less than 20 foot of water left at my well, and once that is pumped out, then my well is dry. And what's so important is the only source of water we have is our groundwater. And what's happening is that for commercial and agricultural water rights issued by the state engineer, is they are sucking the aquifer dry and there's nothing left for domestic wells.
I agree with you, John. As you know, folks, in fact, John, I've mentioned his name quite a few times on this YouTube production. He's been with me, with Frank Mazzario and Kenny Bent, and I guess this week we're going to have Greg Dan with us, and we've been attending these workshops in the Senate Bill Proposal 65 and 81, and it's like we're fighting an uphill battle here. I'm going to let my friend John here explain from his perspective. I've told you my perspective on what's been happening as we've been attending these meetings, but I want John to tell you a little bit from his perspective.
Well, in my research, I think one of the things very, very important is that I do research and I have documents, and so when I speak to a fact, I have the document to back it up. And what I found is that there was one Nevada State Supreme Court decision in 1872 which says that percolating water is contained in the soil and belongs to the land of the landowner. And so basically what is happening is all other state Supreme Court decisions is on surface water. And what's important is there's a difference between surface water and groundwater. And state engineer issues water rights for people to take groundwater. And actually what he's doing is he's taking the water that belongs to the landowner and giving it to somebody else. And now it's been determined that those water rights are real property. So what's happening here is that my property right is being taken from me and given to another individual, and then that individual can suck my well dry.
Exactly. I've used this term before, folks, but any of you that have watched Alice in Wonderland, where she falls down the rabbit hole and disappears into another world that's just totally bizarre and foreign to her, this is what we feel like here in Basin 162 of Nevada Water Basin 162. Nevada is broke up into different water basins, and we happen to be in 162, and it's the job of the state Division of Water Resources and the state engineer, Mr. Jason King, to protect a domestic well owner's water resource. We're a very high priority. In fact, he's brought it up. We are a high priority, and he claims that we we are utmost in his mind. But claiming something and actually doing something is totally totally off kilter here. John was on, like I mentioned, was on the Water District Board, and he would bring these facts up. As you can see on the table here, I'll hold it up here in case you can't see. This guy does a lot of research, and he would bring these facts up, not speculation, not assumptions, just facts from state records, from court records, from geological records, and the studies that the state engineer has to go with as far as managing our Basin 162, go back to 1971, isn't it, John? 1971, 72, the cornerstone?
The state engineer's office was created in 1903.
Okay.
And it was created in 1903, and then finally 1913, they took and created the NRS 533 to manage and appropriate water in the state of Nevada. And basically what the state engineer's office has done is that they have over-allocated the water. In other words, the state engineer has a water basin, and he knows that the perennial yield is 20,000 acre feet, and it's estimated that 8,000 feet continues to flow outside of the basin, so that leaves 12,000 acre feet of recharge per year. And by state law, if he issues a water permit, he has to justify that the water is in the ground that will satisfy that permit. Yet, what you can see is in 1970, the state engineer's office had appropriated water for 91,000 acre feet of water when there is 12,000 acre feet available. And as Judith Holgram in her comments to the state legislature this is fraud, because the state engineer knows that there is no water to back up his paper water rights, and he refuses to call for beneficial use. And what's so important is beneficial use is the anti-speculation law for the state of Nevada. In other words, there's the terminology, you use it or lose it. If you don't use the water for 4 consecutive years, the state engineer is supposed to send a person a letter saying that you have not been pumping your water, and so he gives them 1 year to demonstrate what the problem is, and if they can't demonstrate what the problem is, they forfeit the water. This eliminates water banking. And by water banking, what I mean is like the public utility company here in Pahrump has 27,000 acre feet of water rights that they have converted from irrigation use to quasi-municipal use. And they use only 3,000 acre feet of water out of that 27,000 acre feet of water. Since 1982, the state engineer has not called for beneficial use. He refuses to do so. So what has happened is developers have deeded property to the utility company. And the utility company has put that water right in a quasi-municipal for one of their wells in the community. But that water's not being pumped. And so this is a way of people protecting their water rights. And actually one of the problems today is there's people who are taking water and they're saying they're going to take water out of this bank, which they actually cannot do in my opinion, because they have deeded the water to the utility company. And they had their property rezoned for subdivisions. They've not built the subdivisions.
So there's just a fraud going on here.
It's a
is that they're
Ponzi
just
scheme.
playing a game. These people that used to have the huge farms here, the ones that sucked all the water down, they then turned around and built the subdivision. I mean, they didn't build the subdivision. They took the land, went into the planning department, and had the farmland subdivided into housing developments and proposed shopping center site. And then they took the water that they had for irrigation and they sort of parked it over in the utility company so it would be protected there, because it had the state water engineer came to them and said, well, you're not farming anymore, where's your water? And said, well, we don't have it anymore. I've deeded it over to the utility company, because if they hadn't, then he could have called beneficial use to these farmers, former farmers, now utility owners themselves and developers, and then they would have lost the water.
Well, you see,
Or they could have if they couldn't start pumping it.
yes, and one of the problems is that in 1970, preferred equities wanted to start doing the subdivisions here in Pahrump Valley. And so they wanted to change their irrigation water rights that they were using to irrigate 11,000 acre feet of farmland. They wanted to convert those into quasi-municipal, and the state engineer refused, saying, no, you can't, because it's in the best interest of the people not to do so. So what preferred equity did is they created the utility company of Central Nevada. And then they sold that utility company, which has become Utility Inc. of Central Nevada. So by forming a utility company, they were then able to convert the agricultural water right use into quasi-municipal use. And what they did is they stripped water rights, 5 acre feet of water per acre, they stripped that off. And then when they formed the subdivisions, the state engineer and the health department and the Public Utility Commission said they had to dedicate so much water to the subdivision. So like, for example, if it was a 1 acre lot or more, they had to dedicate 2.2 acre feet of water to that lot. If it was less than 1 acre, they had to dedicate 1.12. So basically, in 2014, Public Inc. took and said to the Public Utility Commission, we have 28,000 parcels in our footprint, but we can serve only 6,400. And at this time, we have 4,700 connections, and we're using 2,800 gallons of water for the present customers.
Acre feet or gallons?
Acre feet.
Okay.
So the thing is that what is happening is the utility companies never put the infrastructure in the ground for water lines. They did put some for sewer. But basically, the utility companies have not put in the infrastructure. So now, what is happening in SB 65 and 81 is they started off that they wanted to say that if a person was, the law says that if you're 180 feet from a public utility, then you have to connect. They wanted to increase this up to 1,000 feet. Now, to do that, you would have to put in a 10 or a 12-inch water line. And so you would take the $5 a foot multiplied by the number of inches of the pipe, and that's what it would cost you for 1 foot in the ground. So like, for example, if you put in a 10-inch line, you would have to have 10 times 5, which is $50,000, and then if you had to put in a line 1,000 feet, it would cost you $50,000 to put that water line in.
That's just to your house.
That's
I mean,
to your house.
front of your house. You still have to go back to the house.
That puts it in front of your house.
You got to go back to where your house is.
And then you got to connect to your house, and then you got to pay a connection fee. Now, when I bought my property in Pahrump, I extended the water line to my property.
Because it wasn't there, right?
Because it wasn't there. And so they extended it for the entire block. At that time, it cost me $10,000 to put that water line in. Today, it would cost me probably $90,000 to put that water line in. I have an agreement that if somebody hooks on, they have to pay to hook onto my water line. After 10 years, then I don't get anything if somebody hooks onto it. But the point is that I extended the water line plus the amount of money that I paid for the lot, and I have an investment in my property that I cannot recoup today in the present market. Now, I took a loss, and it was my tough luck. Well, the thing is that what's really interesting is you have these people who have thousands of acre-feet of water in a public utility, and the state engineer won't call for beneficial use because these people would economically lose. They haven't put the water rights to beneficial use. Now, what that means is you have a water right, say for 100 acre-feet of water, and then you put it to use, and you finally take and you put in the works and you put it to use, and then you send a report to the state engineer. Let's say, for example, you use only 20 acre-feet of water, but you have a permit for 100. So the state engineer is supposed to take 100 and subtract 20, so he is supposed to forfeit 80 acre-feet of that permit. The state engineer refuses to do so.
This is amazing, John. You're covering some territory that I've covered in the past a little bit, and my other guests, but obviously you have way more knowledge about it and more in-depth knowledge. I want to back up a little bit. That preferred properties that you talked about.
Yes.
Let me explain what I found out about them. Preferred properties was formed by a guy that was from Texas. He was a big farmer, wealthy guy down there. And at the time, way back when, this area did have water because they hadn't started pumping all the water out for farming. And it was known that you could come here to the Pahrump Valley, going all the way up through this area here, and it was profitable to farm out here. And the people were farming alfalfa and cotton and probably a few other items. I'm not sure exactly what they're farming. If you think about this, this guy came in here, and he had, what did you say he had 11,000 acres?
He had 11,000 acre-feet under cultivation, and then he had another 16,000 acre-feet of other land that was not under cultivation.
Now, if you heard what John said earlier, there's only 12,000, approximately 12,000 acre-feet of water that we actually can use here in Pahrump for the recharge each year. This one farmer was sucking several times the total recharge by himself, and he was only one farmer. But as it became less profitable to farm, then he formed this utility company that John mentioned, and they sold lots, and I'm convinced at that point the state water engineer was aware of what was going on. At that time, it was a different state water engineer, and he's, for whatever reason, politics, I'm not going to make any statements that get me in trouble here and get liable, but the people that were responsible for protecting the domestic well owners, they weren't protecting them. Because way back then, in 1970, I believe it was only 100 domestic wells in the entire area here, and now we have 11,200. So in all that time that it built up to 11,200 wells, nothing was done to protect the domestic well owner. And it's come to this point where we now have the critical stage where, it's called critical management, but they're trying to change it to a managed basin. And they're asking the people that basically bought the property from these farmers, like this guy that had this 11,000 acre-feet of water under cultivation. He sold us the land. We put our houses here. I didn't, but I bought the house from a person that put the house here way back 25 years ago, I guess. And none of us knew that we were in basically involved in a Ponzi scheme, taking water from one person and giving it to another, and then the last person in line doesn't have any water. Well, we're the last people in line because, as we've covered in the show before, they come up with this term now that people that have senior water rights, those before 1948, they in a sense have own all the water here. I mean, if it gets down to the state engineer calling in a critical area, and he has to protect those people before he protects us. So we're a whole class of people, and if you figure that every family is probably about 2.2 people times 11,200, there's close to 30,000 people in a town of 35,000 people that literally don't have a drop of water if the state engineer decides to make us shut our wells off. So you can see why. I mean, I'm hoping you see through this series of videos and look into this yourself, and we'll continue to. I'm going to have John on in the future more than once, and Frank and some other people I've had, and there's going to be people going on down the line because this is a serious situation, and we didn't bring this upon ourselves. Now I'm going to throw something else out here, John. What is your opinion of the series? Because you've been here a long time. There's what we call the Board of County Commissioners, and every county is really a sub entity of the state. The state is the supreme governing body of the state of Nevada, and then they have the counties, and then you have county commissioners that in a sense run the counties. They are the force of law of the county. What is your opinion? While this was all going on, why wasn't the county and in the case of the various towns like the town of Amargosa, Beatty, and Pahrump, why wasn't anything being spoken out by these people? They're the elected officials. And how do you look at that right now?
Well, one of the things I have found in my research, and I think that what is really important is that the subdivisions in Pahrump have been approved by the county commissioners. And here in Pahrump, they have the Pahrump Regional Planning Board. And these people are the ones that have zoned the town of Pahrump for these subdivisions. Now what's very, very interesting is that you would think that the commissioners would be looking at what the state engineer is doing, and when the state engineer is not doing his job that they would speak up. However, they don't. And let me give you an example of what is very, very interesting, is that there was an order of 1,222 on November 1, 2012. And this was a violation of a county commissioner who had an RV park, and he had 5 acre-feet of water. He was pumping 1 acre-foot of water out, 1 2/10 acre-foot of water out of an approved well. He also made application for a second well, which was denied. He was pumping 9.22 acre-feet out of this unapproved well, and the state engineer sent him a letter saying, "You're violating the law." And he continued to violate the law, and so in basically what he did is he pumped 1.2 acre-feet of water plus 9.22 out of the unpermitted well for a total of 10.42 acre-feet of water.
And he was only supposed to pump 2 feet.
He was supposed to pump 5.94. He was entitled to pump 6, but he's pumping 10. Now in 2009 he pumped 10 8/10 acre-feet of water, and the state engineer had meter reports for 4 consecutive years. This man was over pumping his permit. So finally, the state engineer sends him a letter saying, "You got to correct this because it costs you $10,000 a day, violations, etc., etc." And the end results of that is unknown, because after the violation order was put out, the outcome of how it was settled. Now this is a county commissioner who's sitting on the board.
Is he sitting on it today?
No, he was voted out.
Okay.
But the point is we have elected officials that are violating the law themselves, and they're doing nothing about it to protect you and I.
And this is an ongoing situation.
And this is an ongoing situation.
Okay, I'm going to stop there on water for a minute, because there's a report. Okay, as you know, the county is crying uncle that they're broke. They don't know where their next dime's going to come from. They don't know how they're going to service the population here. The school district is having all sorts of financial problems. And here's what I find funny about this. It's not funny, it's another tragedy. The county spent $60,000 back in 2005, 2006 to a company that's called Tischler. And Tischler does studies. I'm going to hold this up. I hope the camera can see it. The company's called Tischler Bice, and it's called Fiscal, Economic, and Planning Consultants. That's what they are. And this is a copy of the front of the report that they did that covered Nye County, it covered the town of Pahrump, and it covered the Nye County School District. And it's 120, I believe 122 pages, 124 page long report, but I only copied a few items here. And now what they did, the county commissioners, and I even have a copy of the Nye County agenda form right here on the front here, and this became an agenda item, and I'll read you what it says. On January the 30th, 2006, Paul Tischler submitted the second part of the work on the cost of land use study to staff, which was distributed via email to the board members on January the 31st. Staff also went over the document with Mr. Tischler and Pahrump on February the 8th. Mr. Tischler must now present the document as his findings to the board to complete the work on the project. So in other words, the information in this 122 or 24 page study is well known to the commissioners. And since this is 2006 and we're in 2015, we have current commissioners sitting on the board that heard this report and know of the report.
I believe one.
Huh?
I believe one.
There's one now?
Yes.
One left? But there is one. Have you ever heard this report mentioned, John, in recent years?
Yes, I have brought this report up several times in public comment, and I've pointed out the importance of the Tischler report. And I think one of the things that's important is that this report had three sections, and one was the development of land use assumptions, and number two was a slow growth plan, and then number three was a fast growth plan. And so he analyzed these three for each of the entities, which was Nye County, the town of Pahrump, and the Nye County School District.
Okay, so in other words, it was, I don't mean to interrupt you, I was just clarify this, but the report, the report would be if the town was at slow growth, in other words, very little development going on, or if it was at average growth, or if it was fast growth, like we were experiencing back in the
2006 to 2008.
Yeah, there was a lot of development going on, wasn't
Yes,
there?
there was.
And they had this report.
Yes.
Even though, and they had this report. Now, why don't you maybe you can explain what the county was told if the development would go forward.
Okay, in the report, in the summary, all development scenarios produce annual net deficit yearly revenues minus expenditures to the county over the projected period of time, with the exception of the first year under the fast growth scenario. So basically this report said that all three
Entities.
was a net deficit to each one of these groups, and only one out of the 9 was a break even. So what this man was telling them is that whatever they did in development in this area was a deficit.
Financial one.
Financial deficit. And if they continued along this line, in 5 years' time they would have budget problems. Well, in 2008, when the economy folded, in the last 5 years, we have had deficit problems.
Yes, we have. In fact, going back to 2007, and I mentioned this before, every year there's been less and less revenue for the county coming into the coffers. And they were warned about this, and so in fact, they knew for 2 years when it was just still rapidly building. And when I say rapidly building, it was going on over South Nevada. You could drive from Las Vegas out Blue Diamond Highway Road, I guess you call it, and then it becomes Highway 160, which comes to Pahrump and then on up to reconnects with Highway 95. There, you could literally, it was like watching a garden grow. You could go into town and the next week go back and there'd be another development popping up. And this was happening here in Pahrump throughout this whole area here. Yet there was nothing being done, was there?
Don't get confused between what was happening in Las Vegas and what was happening in Pahrump. In Las Vegas on Blue Diamond, it was accelerated building. And then here in Pahrump, there was also accelerated building. And then it folded. And so you have all of these proposed subdivisions that the developers are saying economically they can't build. And they have all of these permits. And one of the things that's interesting is the county has given some of these developers 20 years' time to produce these developments. And
okay, go ahead.
And the thing is that here in this particular case is that they're concerned about a large developer losing his money, but they're not concerned about the little guy losing his money.
You and me.
Yes, I lost money.
I know
And nobody was concerned about my economic loss.
No, they weren't.
And as the chief of the Indian reservation says, water flows to the money.
Well, I think that's right. And the reason I brought Las Vegas up, I wanted to point out that now Las Vegas is booming again. They're continuing to build. They have a very similar water situation in Las Vegas in that there's less and less availability of water and more building. And here in Pahrump, they are chomping at the bits. There's 2 brand new real estate firms that have opened up in Pahrump in just the last month. And why? Because houses are starting to sell, and they're starting to snoop around land developments. And if you go to the planning department meetings, which are held each month, you see development starting to be talked about, building. Now remember, this Tischler Report says that for every time, in a sense, a house or commercial building is built, that the county is losing money because they don't have the money to service the new customer that's going to be in the house, the new customer that's going to be in the building. They claim that, they're clamming around trying to find out how to cover expenses. They're proposing new gasoline taxes to improve roads. They're snooping everywhere, trying to beg money from the federal government, from the state, wherever they can get money. Yet they've known for 10 years that continued growth like this was going to be unsustainable as far as the budget for the county. So we have a county commissioner that was using twice as much water as he legally is allowed to. We have county commissioners today that are approving planning department building proposals without so much as a squawk about what it's going to cost the county. And these are things that you people watching this need to bring up at the meetings, and we're going to bring them up because you can't, on the one hand, claim you're going broke as a county. On the other hand, go ahead and continue to let overdevelopment go on. And by the way, as we mentioned earlier in the program, there's no water for the development anyway. So I don't know if you have anything more to add on that subject, John, but I got one more thing to move into. If you
Go ahead.
Okay. The makeup of the boards, the people that are making the decisions.
Which board?
The Water District Board,
Okay.
the advisory boards having to do with water.
Okay. I just wanted to clarify that.
Okay. The county commissioners choose who are going to be on these boards. And these boards are the ones, either it's called an advisory board or it's in the case of the Water District Board, it's actually an entity that has money coming into itself to support its activities. The county commissioners cherry pick who sits on these boards. And one of the people that I'm hoping to have him on a program in the future here is Kenny Bent. And Kenny went to a ethics board meeting because I believe he's an alternate on the Water District Board.
No, he's an alternate on Basin 162.
Okay. And so when you're on these boards, that they want you to go to these meetings that the state teaches you on how not to break ethics, or how not to create ethics violations. And I got a letter here that Kenny sent off to the person that he went and got the training from recently. And basically, what he asked the guy is point blank: is it unethical or illegal for the county to be cherry picking these boards so that the people that are running the boards, chairing the boards, controlling the votes of the boards are all special interests? They're the developers and the utility companies, with a token one or two people that actually have, are a citizen of the valley. Now, it doesn't have anything to do with in a sense, it doesn't have anything to do with whether you're qualified to sit on these boards. There's plenty of qualified people here, and one of the reasons people that come forward and shout the clarion horn is because they are aware of what's going on. They are intelligent, and those people are the ones that they don't want to have sitting on these boards. They don't want to have anybody rocking the boat. Now, do they, John?
Well, I was appointed at the at-large position for the Nye County Water District. And I think the thing that's important is the Nye County Water District is an entity separate from Nye County. And it can collect taxes, and they have their own budget and everything. There's one caveat, which is the members of that board are appointed by the county commissioners. Now, that board collects $5 on every parcel in Nye County. And the purpose of that board is for them to develop water or sewer systems that is not available in the utilities. They set aside in the budget money to buy water rights, and since they've been created, they have never bought a water right. They collect this money, and now what is happening is the Nuclear Repository Office has closed down, which Darrell Lacey was the head of that. Now Darrell Lacey is the head of the Water District, and so they have taken the projects of the Nuclear Repository Board and they have pushed it over onto the Water District, and they are continuing to fund the projects of the Nuclear Repository Board. And basically what they were doing there is they were analyzing monitoring wells to make sure that the radiation from the test site doesn't bleed into our water systems. Now, that in itself, I agree with that type of testing, but I don't agree with the fact that they transfer it from the repository to the Water District, which is not in the powers of the Water District. The other thing is that you have Round Mountain Gold, and one of their members is a hydrologist for the mining company. The mining company has a subdivision up there where they can't afford to do the environmental impact for the sewer systems and water systems that are failing. So the mining company says, we'll put up $11,000 if you will put up $11,000. So the Water District loans this community $11,000 of taxpayers' money,
Our money.
to solve their problem, and it is not within their power, and they give them a loan of 5 years at 0 interest.
This is Round Mountain.
And this is up in Round Mountain. There is no agreement between the Round Mountain Corporation, the subdivision, or the county. There's no mutual agreement that's ever been agreed upon. They have just flat lent the money. It was brought up that this was not within their powers, and then they take and say, oh yes, we have an attorney's opinion that it is within our power. And this board is also wanting to meter the domestic wells. Basically, when you take a look at this, I was appointed to that board, and in a 4-month period when I took and pointed out you're not following your bylaws, you're not following the powers that you have, is that when it came time to be reappointed, I was not reappointed because they needed to appoint a rubber stamp. So they appoint a person that works for the Ponderosa Dairy who's in charge of irrigating the fields and the water rights for the dairy. Now he's retired from the dairy and he still is on the water board. But my point being is that if you're not a rubber stamp, you're not appointed to the board.
Well, as I understand it, one of the current commissioners we have is from up in the Round Mountain Smoky Valley area. Let me explain where this, folks, when we're talking about these valleys and these towns, I've mentioned this in the past, Nye County is, I think, the second or third largest county in area-wise in the United States. So to find out where Round Mountain is, you have to drive from where we're sitting right now, filming this, in Pahrump, about 175 miles up to Tonopah, and then from Tonopah you take Highway 6 out 10 miles, and I believe the highway that you turn left on is 372. I may be mistaken, 373 maybe. You turn left there and you drive another 30 or 40 miles and you come to Round Mountain. And Round Mountain would be what you might formally call a company town. Round Mountain
Gold
Mining Company is there, and so the town exists because Round Mountain Mining Company, there's really nothing else up there in that area but the mining. So they've gotten a special loan with my money, because, by the way, those parcels that were taxed, most of them are down here in Pahrump. We have, between Tonopah and Pahrump is where most of the people live in the county. Even though we're a very sparsely populated county, most of the people are right down here. So we're paying for this mining company's sewer and water project up there in Round Mountain, and I guess that's just fine with the people living up there. But this shows you an example of some of the little deals that go on, and it's really good. It's frightening in a sense, because we're living in a situation where our water is being threatened, our supply of water, and yet the county commissioners, these planning boards, these water district boards, they all seem to be in collusion along with the state water engineer and the Division of Water Resources to deprive us of our asset. And so if people watch this wonder why we're upset, why I keep covering the same subject in my blog on Tilting Windmill and these videos, it's because it's a clarion call. I'm trying to get the word out that, by bringing people like guests like John in that have studied this. I mean, the material he has here, this is not just a little bit sample. This is just a sampling, by the way. He has other material. He keeps coming to the meetings like I do. We get up in front of these boards. We say our public comment, and then the commissioners have the audacity to tell us, well, we let you have the comments, but rarely does your comments ever change our mind. That we are in possession of all the facts, and that we know what's best, and so we go ahead and vote. Well, it's true. They have all the facts. They got the Tischler Report. They've got the 1971 report from the geologists telling us about the state of our 162 basin here. They have all the reports. They ignore the actual evidence in the reports so that they can keep overdeveloping the area. And the stupidity of this, as they continue to overdevelop the area, the county becomes less and less financially solvent. It's just a rabbit hole, John, we're falling down in.
Well, one of the things that's kind of interesting is when you take the 1971 water report, is basically Las Vegas was having problems with enough water. And so they had a study made where they wanted to reach out to 5 areas around Las Vegas, and they wanted to do water mining. They wanted to take the first 100 feet of the aquifer and mine it and ship it to Las Vegas. And so they did a study of each basin. And when they found out the multi-million dollars that it would cost to transport the water from a basin, like, for example, I think it was something like $20 million to transport the water from the Pahrump Basin, 162, to Las Vegas, and then they also studied the Amargosa Valley water area. And they wanted to import this into Las Vegas. Well, what Las Vegas was able to do is they calculated a better agreement with the Colorado River, taking water out of Lake Mead, so they abandoned the mining of the 5 areas because of the cost. Well, then state did nothing about interbasin transfers until 1990 when Las Vegas started running out of water. And so the McGill smelter in McGill, Nevada shut down, and that's one of the huge water sources in northern Nevada, which is used for the state park, for the elk and etc., which is a beautiful area. And now they want to transport that water out of northeastern Nevada down to Las Vegas. And so what they've done is they have bought all of these ranches, and they have stripped the water off of the ranches, and then they've sold the ranch property for next to nothing because there's no water available, and they're building a pipeline. And so finally the state engineer gave an order that it was permissible for them to do such. And so the Mormon church, which has a farm where they raise beef for their common warehouse, filed a lawsuit, and the district court ruled that the state engineer didn't have enough information to justify his order. And so basically the court decision of the district court is final. So they appealed it to the Nevada Supreme Court. The Nevada Supreme Court says that they won't look at it because the district court is final. So now what they're trying to do is to again strip the water out of basins that got large amounts of water, and to continue the overbuilding of Las Vegas. And what you have to realize is probably Las Vegas gets about 90% of their water from Lake Mead. They've had to drill their source deeper to where they're going into the very bottom of Lake Mead, and basically they can't put a pipe into Lake Mead, so what they're doing is they're drilling a tunnel, and the water will come into the tunnel, and then the pipe will pick it up out. Everything they do is to circumvent the law. And if that all collapses and Las Vegas is overbuilt, where are people going to get water for Las Vegas?
I have no idea, John, because it's not only that, but that Nevada cannot gobble up any more Colorado River water than there's a pact called the Colorado River Pact that covers the allocation of the Colorado River water as it flows from down the country through Utah, Nevada, Arizona, California, and each state was allocated a certain percentage of that flow. So there's no way that Nevada can go and steal Arizona or California. In fact, Mexico even had a portion of that. And as the United States, we've robbed them of their portion. Where the Colorado River is supposed to extend down into Mexico, and I forget what the name of this town is, that city down there, the California, Arizona, Nevada, and I guess Utah have used so much water that the Colorado River disappears into the desert before it reaches this farming community down in Mexico to just a mud puddle, I guess, that evaporates. There's no water to reach it. So there's no water reaching there. How could there be any more water for Nevada up here? But it shows you that the state engineer, I mean, it's like he's juggling all these facts that he's aware of. And here in Pahrump, we are the low-hanging fruit, the domestic well owners. He worked, not him, but other state water engineers and the county commissioners and officials allowed this overbuilding to go on. The ones in Clark County for Las Vegas, which is in a sense controlled by all the big casino moguls and the billionaires, they've allowed the overbuilding to go on down there, and it's a big Ponzi scheme. At some point, there's going to be somebody that's going to move into a $500,000 house in a subdivision, and he's going to turn his tap on, and a couple of brown drops are going to go out, and he's going to, where's my water? Well, I'm sorry, you're the last sucker that bought into this scam. And then I don't know what's going to happen. I don't know if there's going to be a water war. I don't know if they're going to try to steal water from the state of Oregon or something. I don't know what the state's going to do.
Well, actually what happened is that basically Arizona was not using 4 million acre-feet of water, and Nevada was not using 1 million acre-feet of water flowing down the Colorado River. And finally Arizona sued and won the lawsuit that they could take that 4 million acre-feet of water and recharge the basin. So Nevada has an agreement with Arizona that Arizona is recharging their water table with 4 million gallons of water, and then plus the 1 million gallons of water, acre feet of water for the state of Nevada. So that 5 million acre feet of water was flowing into California, which California was using in Southern California. So when the court case came down and California could no longer use that 5 million
Our water.
gallons of water, then they had a water crisis, and basically their water law is based upon riparian water, which means surface. And California had no requirement on groundwater. There was, you could drill a well and take as much water as you wanted. So they had a special session in 2014, and now they have new laws in California about the groundwater and control the groundwater, because they're using the groundwater to supplement the surface water. And so California has this tremendous drought problem. They have this tremendous lack of water because Nevada and Arizona won the lawsuit. And so actually Nevada is banking 1 million acre feet of water in Arizona, with the understanding that when Nevada needs the water, Arizona will put the water back in the Colorado River so that it'll flow down and they can take the water out in Lake Mead.
Okay.
And so you're right about the economy in Mexico, and now Mexico is suing because they're supposed to get 15% of the Colorado River, which
And they're getting zero.
Well, but you see, the thing is agriculture has moved from Southern California to Mexico, and most of the produce that's being produced today is being imported from Mexico. So now the Mexicans are saying, we want our water.
And they have a legal right to it.
They have a legal right.
A treaty.
They have a treaty.
A water treaty. This is going to go on and on, folks.
Well, look at the example when you and I were in the elevator in Carson City when we went to the workshop, and we're talking about our problems of water, and here's people from Utah saying they're having exactly the same problem.
People on the elevator with us.
And the people said, do you have an attorney? And we said, no, at this time we don't have an attorney. We can't afford one. So they said, we'll talk to our attorney and have him call you and see if he can help you, because he can practice in Nevada.
It's amazing, John. John, by the way, and Frank Nazario are the two individuals that have sued the state water engineer here in district court in Pahrump. The suit that's going to be coming up, I believe the first hearing is on March the 17th in Judge Wonker's chambers. And I urge anybody watch this that is down here in southern Nevada to show up at the courtroom. It's going to be interesting as this court proceeds. I'm sure that the state is going to have all the big guns there, because...
They already have. Let me explain what's happening.
Okay, you tell us what's going on with the lawsuit, John.
Well, basically, we filed a lawsuit asking for an injunction to stop the state engineer from asking for the changes in SB 65 and SB 81. And so since the state engineer office is represented by the Attorney General's office, is they waited up until the very end of the 20-day period where they had to answer. So on the 24th of the month, they send opposition to our motion with a declaration from Jason King. And yesterday we received then a notice from the Attorney General's office asking the court to just simply not hear the case because it's irrelevant. And so what's happening is Frank and I are both retired. We filed the lawsuit in person, pro se, because we haven't been able to find an attorney that is willing to represent us. And if there's any attorney out there that is watching this program who can practice in the state of Nevada and is willing to do work pro bono or at a very reasonable fee to represent us on the 17th, please call me at area code 775-372-9038, because we are being just overwhelmed by the Attorney General's office with all of the tactics that they don't want this heard in the district court because of our example bringing out the fact that percolating water belongs to the landowner by a state Supreme Court. That case has never been appealed, has never been overturned. In fact, the state of Nevada Supreme Court has not talked about percolating water since 1772. And so all of these court cases that they're bringing up are court cases that are based upon the surface water on rivers, creeks, and etc. on the surface. And they're saying the state engineer has control of all of these. In 1913, when the 1913 Water Act was proposed, it was declared that sections 8 through 84 were unconstitutional. And so that was rewritten in 1915. The 1915 revisions were challenged in the Nevada courts and finally was heard in federal court in 1917. And Section 1 of the Water Act, which says the state engineer owns all water above and below the surface for public use. And the district court took and said that that section I can't think of the word they used, but in other words, what they were saying is the water had already been appropriated, and if it had not had been appropriated, that it belonged to the federal government because of the Mexican Treaty of 1864, which is the Treaty of Guadalupe. What is interesting is all of the land in Pahrump is by state patents, and the way the state got control of that land is in 1880. State of Nevada said to the federal government, we have all of this land available for the 16th and 36th section, which was 4.9 million acres. And we will select 2 million acres, and we will give you back 2.9 million acres of land. And the federal government agreed. The federal government issued patents to the state of Nevada in 1883 through 1838, and then the state, and it was stated that all land had to be sold by patents reserving the valuable minerals, and every piece of property in Pahrump Valley is a state selected land patent. And with a land patent, that means that the soil of the land belongs to the landowner. And basically, all of the water rights, in my opinion, all of the water rights issued by the state engineer in this basin, he has no water because there is no state water, there is no state land, there's no public land where this water is flowing across the land.
It's just land patent for the owners of the land.
The land belongs to the private people, and so what he's doing is he's taking the property right and turning it into a privilege, and then he's giving that to somebody else. And now the state Supreme Court has ruled that these water patents are real property, and they can be bought and sold like stock. So what they've done is they've taken our private property, converted it to a privilege, then they've issued the water right, and the state Supreme Court says that's real property and can be bought and sold. So those people own the soil of our land. Our land has been stolen from us.
Let me throw something in here because
without compensation.
Yeah, to bolster, I guess, what John just said. My wife and I pulled out all of the paperwork we had for our property because we own the property here free and clear. So we had, we've got the legal documents that explain, all of that. And I have never seen this before because I've owned homes in Washington State, Oregon, Arizona, and now here in Nevada. And in those previous states and communities I lived in, when you looked at the title on your home, your property, it excluded the mineral rights. It excluded, and it would list like oil, gas, any
valuable
those
minerals.
were all held out. In other words, I own the house, the land, but anything of value underneath the property belonged to the original person that had that property. The railroads, generally when you'd look at it, it'd be like a railroad would own that land, because railroads were, when they came across the country, they were allotted every other section of land, as I understand, on each side of the tracks. And so where communities would pop up, it would in a sense be land that the railroads had. And so the railroads had stripped out all the minerals and sold you the land, but it didn't come with a mineral right. Well, here in Nevada, in Pahrump, I'm looking at the document yesterday, and and I'm sure if you pull yours up, John, it'll probably say the same thing. Or you in the audience will live here in Southern, and you're going to notice that you have all of the mineral rights and everything underneath the ground, and this water is part of your property. I not only have the land I've got the house on, I own the property underneath my house, because that's the way this land patent, I guess, works. That we own everything, because it's not,
They own everything below and above. I think one of the things I'd like to correct you on is that, number one, the states that you mentioned are also one of the states that came underneath the Treaty of Guadalupe. And when the land patents were issued by the United States government always took and said that the valuable minerals had to be reserved. So on the land patents, the mineral rights are reserved. Now the land patent is that if the land patent is going to reserve anything, it has to be stated that it's reserved. Now the thing is water is not reserved. The state did not reserve any water on the land patents that they issued. They only reserved right-of-ways for places that they had for telephones, or
like
ditches,
streets or something.
ditches or canals that were built by people on federal land. They reserved that, but that was just the ditches and canals, and valuable minerals was reserved. Everything else goes to the property owner, and whatever the United States government received in the treaty is passed on to the landowner.
So that's what I was saying, John, was that everything that on this property where we're sitting filming this belongs to me, above and below. And that includes the water that's mixed up with the soil underneath my property.
That's correct.
And they are in a sense in the process of they're declaring it. They're saying outright, we already have your water. The state owns your water. They've not once come up to me and said, well, we need your water. We're going to do an eminent domain case, and we're going to pay you for the value of water. They're not offering to pay any of us anything for loss of value in our homes, loss of water. They're just taking. And if this is allowed to go on, it'll set a precedent that'll be, it might go nationwide, I don't know. I mean, if a state can come in and take people's private property without having to give any, well, for one thing, without having to prove that there's a case for an eminent domain for them to take it for some public use, then it's just going to disrupt the whole concept of private property laws, private property rights, violation of our U.S. and state constitutions, and yet this is what's going on right in front of us right now. Well, I'm going to have to probably call this. We've gone way over here, and John is going to. I hope you come back, because
I'll be back. Thank you.
Yeah, because John is one of the people that I consider the true experts on water in the state of Nevada, and on research. He's impeccable on the material he digs up. I'm retired like John. For you younger people that have question what we talk about here or laugh about it, I've read some of those social media posts where it's really hilarious, because John and I, we're in our twilight years. We're actually fighting because we believe it's the right thing to do, to defend the Constitution of the United States and the state of Nevada, and to ensure that we get everything we have coming out of our elected government. But one of you is going to come at some point in time, is going to come and buy both of our property. We'll be long gone. And if you buy it, you may or may not have water on it, because it's all going to come down to these, the actions going on right now in the legislature. And we can put a stop to it. We can throw these people out of office. we can make a loud enough stink that that we may stop some of this. But I'm going to call that a day, folks. And again, this is Right Talk with Dwight Lilly, your host. Till the next time. That was a good